So first of all, welcome. Thank you so much, everyone, for joining us on this webinar today, Garden Court Family Team webinar. It's the first one we're doing in response to the current pandemic. It won't be the last one, but it's great, and we're very grateful to everyone for taking the time out to join us. We appreciate you doing so. We hope in return you will be able to enjoy what I think are some very stimulating and informative presentations today that we've put together. Obviously, we understand at Garden Court, and I'm sure everyone else does, that we're in very troubling and difficult times at the moment, both personally and professionally. And doubtless amongst us, there are those who have experienced the consequences of this pandemic firsthand through family and friends who are health workers or key workers, those who are high risk and in self-isolation, and the added pressures and strains that's putting on a very challenging situation. And of course, many of our clients are some of the most vulnerable people in society at the best of times, and they are facing real hardships and difficulties during this pandemic in a disproportionate way, both physically, medically, and probably financially, and they'll be looking to us as lawyers to help and assist them. As I said, this is the first webinar that the family team have been doing, and we're hoping that it does provide some sort of mutual support and reassurance and guidance to help us collectively sort of navigate our way through very choppy, uncharted waters together. The crisis continues to throw up new and unexpected challenges to us as lawyers and those we represent. And it makes it increasingly difficult for us all to continue to provide that high quality of care and professionalism that we do. And in these presentations today, we hope that we can give you, as I say, some guidance, discussion points, and help in those regards. The Garden Court family team, as ever, have put together a fantastic array of speakers who will be very well known to many of you. They don't need introductions, but I'm going to be giving them each a little introduction before they do their presentation. The speakers will speak for around about 15 minutes each, and the slides, they will be sent out after the webinar, so don't worry about that. There is the chat where you will be able to, I'm just looking through the chat now to make sure everyone can hear. The chat in the chat section, if you put in your questions as you're listening to the sessions into the chat, what I'll do is I'll make sure I moderate those, and we'll have about half an hour, perhaps a little bit longer at the end, where we can deal with questions and discussion points. But it's also up to the individual speakers. They may actually see questions as they're doing their talk that are more relevantly and more properly answered as the session goes along. But there, as I said, there will be time at the end for us to put questions. Just a few housekeeping matters. At the beginning, when you logged on, you should have seen a little set of instructions, but I'll read those out again now. Please keep yourself on mute unless you're speaking. Please post your questions in the chat window so the speakers can respond at the appropriate time and point in the webinar. Presentation slides will be circulated to registered participants. And this webinar is being recorded. What that means is the audio and video of anyone who speaks will be recorded. No other audio, video, or personal data will be recorded or shared. Without, let me just, as I said, let me just run through to make sure there is nobody who is having any difficulties. I see, Maggie may have difficulties hearing. Let me just see if Amy can resolve that. Maggie Jones says she can't hear. Shanti, I think you're okay now. Can you hear all right?
Alison, it's Maggie. I can hear okay now.
Fantastic. That's great. And Shanti, you had some problems. Are you okay now? Can you hear everything? I take that as a yes. Nicole, you mentioned that you were having difficulty seeing people. Can you see myself and Rebekah, who's going to be the first speaker?
Muted.
I've unmuted.
Yeah. I can just see you now on the right hand side in a little square, and then the talk poster is taking up most of the screen. Is that going to be the slides anyway?
Yes. And once I've finished, once I've introduced her, you should then be able to see Rebekah, and yeah, and we can get on our way.
That's great, thank you.
Natasha at Child Law Partnership says no sound. Natasha, if you...
Oh, that was ages ago. I'm all sorted now, don't worry.
Fantastic. Right, well then I'll move on to our first speaker, who is Rebekah Wilson. Many of you will know Rebekah. She's one of our senior members of the family team. Rebekah has a wealth of experience in representing families, children and guardians at all levels, and has been involved in a number of important, high profile and complex High Court matters. Rebekah regularly writes and speaks. She's written articles for a number of the family law journals and publications, as well as speaking at a number of national conferences. Rebekah has recently been involved in a 15-day fact-finding case in the High Court in front of Justice Headley as junior counsel for one of the parents. That was done remotely, so hot off the press, Rebekah will be able to tell us exactly what it's like doing remote hearings in the new world we're living in at the moment. So without further ado, over to Rebekah Wilson.
Okay, thank you, Allison Munroe QC. Can you hear me? Allison?
I can hear you well.
Okay, so thank you, Allison Munroe QC. Just very nice to say that, and congratulations again to Allison, which was some really good news this year in a sea of unhappy times. I did want to talk to people about Zoom hearings, which is what I've had experience in recently. I have had experience with Skype business and telephone hearings, but Allison is right. I've just completed 11 days in using Zoom, and I've done hearings in front of 2 other High Court judges with Zoom as well. High Court judges seem to like Zoom and seem to be going ahead a lot with their hearings using it. I know it's varying geographically. What I would say is that it can work. Of course, it's not for every case, and Weston QC is going to talk a little later on about the importance of the safeguards, the right to a fair hearing. For example, Zoom is not for every hearing. The hearings that I've done have been ones where the parties have all agreed that for various reasons they don't want any delay and that they can participate this way. And so we haven't had to deal with some of the complex issues about when fundamentally it can't go ahead because it would be unfair. These provisions, of course, in this era is temporary, and we have to be really careful about the fact that it's really good that we get used to doing things this way, but this has to be acknowledged, I think in every order really, that this is a temporary way of handling things because it's just not as good. Sorry, I turn my back because I'm worried about my children walking in. It's just not as good as going to court, seeing your client, having all of those discussions. So whilst we do need to get into the swing of this, we have to remember that this is not to be a permanent change, and I think we have to really guard against that seeping in. It's a really difficult time for all of us. It's really nice to see some familiar faces on a screen this evening. Of course, it's not the same as seeing you all in court. We are here, so if there's any questions, either during the talk or even after, if you're worried about your first hearing that's by Zoom or Skype, I'm sure that if you reach out to any of us, we'll try and help you where we can. You're not alone, and I hope this isn't going to last for too long. But in the meantime, you can feel confident that you can manage hearings by Zoom and by Skype, which I've found Zoom to be the best. just moving on then to deal with, and I'm hoping that James is going to assist me here, there are two important documents that if you're conducting a Zoom hearing, I think that you should pay attention to. You are probably, like me, quite overwhelmed by a number of emails on a daily basis about the different types of things you should be doing, different guidance from HMCTS. So these are just two key documents which please familiarise yourself with if you are conducting a hearing by Zoom. The first is the document from the Family Law Bar Association, and this is from Darren Howe, and it's a really full guide about conducting hearings by Zoom. It gives you all the instructions about how to use it, and it sets them out really clearly. It talks about pricing. Of course, Zoom is free to anyone calling in, and to have a license yourself is a lot more affordable than Sky Business, which is why some people have found it preferable. The important thing to highlight, because there's been some concern and some misinformation about this, is that it is secure and GDPR compliant now. We do also have to do things to make sure that it stays that way. So, for example, when you're scheduling a meeting, which I think we've done with this meeting, you have to get people's consent when they join the meeting to the fact that it's being recorded by the host. Only the host should be recording the meeting. They should be recording it to their own device, not onto the cloud of Zoom. And once the recording is over, if it's a court hearing, that recording then immediately gets sent to the clerk of the rules or the responsible person at the court, and it gets deleted from your own device. And that's obviously incredibly important if you're using Zoom, that you are not recording it yourself and the person recording it doesn't keep a copy themselves. Just in terms of swearing in witnesses, we asked people to confirm the contents of their statement in the usual way, but we also asked them to confirm, one, that there was no one else in the room with them, and two, that they weren't separately recording the proceedings. And of course, you'll know from the COVID-2020 Act that it's actually an offence to do that now. And so we just reminded people about that. So if you're doing a Zoom hearing, Darren Howe's document by the FLBA is the #1 document to look at, first of all, full of really helpful tips. How much is the license? I think you can get a license. Sorry, I'm just going to deal with some questions that are ones that I can deal with easily now. In terms of the Zoom license, you can use it for free, but there's a limit on time and the number of participants, so probably not suitable. And then it's about between $9.99 and $12.99 per month. And you do need that license for meetings of more than an hour. Can I say there are lots of chambers, like our chambers and quorum chambers and One Garden Court, who've been organising Zoom hearings for courts. So we've got a license and we're able to host a number of meetings or a number of hearings. So we've been contacted by judges' clerks, for example. We're able to then host the hearing and set that up for you. So if you don't have your own license, then you can approach us if we're involved in the hearing, and we can see if our clerks can sort out the hearing for the court. This happened with Mrs. Justice Leven today, and it worked very well. So moving on to the next document, James, if you can. The second document that you really must be familiar with if you're using Zoom, in fact, if you're using any of either Zoom, Skype, or any telephone hearing at all, is Mr. Justice McDonald's version 3 of the Remote Access Family Court. He, of course, has been prolific in his writing about dealing with managing remote access hearings, and we've had 3 versions of this document in quite quick succession. I'm hoping that we might pause on this one for a while. It's very up to date, and in red are the parts that have been changed. That, of course, deals with Zoom. He sets out the framework for Zoom hearings. There was a point in time when we were doing our hearing in front of Sir Mark Headley where we were slightly concerned that we might have gone rogue, but clearly we hadn't. And he sets out in his document why we haven't. He deals with Zoom. He points out that a number of High Court judges have been using it, and it's at paragraph 7.9 that he sets out Zoom. My feedback has been from judges and counsel is that they've been struggling with Skype Business. Skype Business is expensive to have a license, which is why I think High Court judges have got to grips with Zoom and seem to prefer it. So we will have to see what happens. There's been a lot of bad press about Zoom. They quickly changed their some of their structures to deal with a lot of those concerns. And Darren Howe sets out in his document why it is that it is secure and GDPR compliant if you follow the steps set out in his document about how to maintain security. So that's Mr. Justice McDonald's document. I'm not going to go into too much detail because I know that that's what James is going to talk about in much more detail shortly. And then I just wanted to talk about my own experience, and I hope this is helpful, about a Zoom hearing. And I've had 2 short hearings, and I've had the longer hearing in front of Sir Mark Headley, which was the Re-A number 2 Children Findings of Fact 2019 EWCA Civ 1947, which was the appeal from Lord Justice Hayden. And the third fact finding, an unprecedented third fact finding, we of course started the trial in front of him at the High Court quite nervously in week 1, as the rest of the country started to move towards the imminent lockdown. And he was intent, as were the parties involved, that there could not be any delay because it's been hanging over, which is public knowledge, the family for a number of years now, and they've had to sit through now a third fact finding. So for very compelling reasons in terms of participation, they wanted it to continue in this way. Practically, overnight, we had to work out how to move 12 counsel from a courtroom, paralegals, 6 expert witnesses and 4 lay witnesses to giving their evidence via Zoom. But we did manage to do it. So I think if we managed to do it, it kind of indicates that it does work really well. One thing that we did straight away was we all muted our videos and sound if we weren't on camera, so that the cross-examination seemed more natural. You could see the person asking the question, you could see the person answering, and you could see the judge. The family had one device that they shared between them. It was an iPad. I have heard of cases where courts might consider support and financial assistance being given to a family so that they have the facility to join the meeting. You can use a phone, of course, if you have access to a phone, but one thing we might need to deal with is what we can provide in terms of allowing lay parties to be able to participate. The experts obviously found it quite easy because, of course, in family proceedings, we're very used to experts giving evidence by video link. And all I can really say is that the connection on Zoom was a lot better than what I've experienced sat in a courtroom in either East, West or Central Family Court with the person appearing via video link there. It didn't have the same delay, so it worked very well. And Lord Justice Headley, who of course, we were all very conscious of the fact that he was within that vulnerable group as he ploughed on with the hearing in court. He got to grips with it very speedily, and I did, and I'm really not the most savvy at these things. So if I can, I think really anybody can. In terms of just communication with the client, that was something that I had to grapple with, because overnight I went from seeing my client every day and speaking to him every morning, being able to take instructions about the evidence, to not having him obviously with me. And so of course I just made arrangements about speaking to him over his phone and just having breaks to enable that to happen. So there were just practical things to think about, really. We got through 6 experts in the first week. And then we had the lay parties the following week. I mean, it's difficult to gauge because they're lay parties who've now given evidence for the third time in the third fact finding. So perhaps in a way it was easier because we knew what questions might be asked. And we haven't had the judgment yet, so we'll see how well it did work. So really that's all I wanted to say about Zoom, that it's very simple, it's very accessible. One thing I did just want to share, and I don't know if James can do it, otherwise I will do it, but if you're in your Zoom meeting and you go to the top left-hand corner, there's a feature under meeting to keep on top. So that means so that if you're having a hearing, and in our case we had the 16 bundles to look at the same time, you can see the speaker on the top of the screen, but then you can also carry on reading your documents on your same device. So you don't need to feel that you need more than one device. You can do it all easily on one device. So I think on that note, I'm going to hand over to James. I'm just being asked to explain a bit more about the family sharing an iPad, so I will do that. So that means when they were watching the expert evidence, then of course they could sit together and use the one device as they normally would. But when they gave their own evidence, they were in a room on their own, and at the outset of their evidence, they were asked to confirm that they were on their own, that there was no one else in the room with them, which obviously is a big concern. They both had their holy book with them, so they were able to swear, and that was how they chose to give the oath. Of course, lots of people won't be able to do that, but that's not necessarily a problem. And counsel just read out the oath to them, and they just copied what counsel was saying. So that's how it worked with the family sharing an iPad. They just had to confirm that they were on their own. Thank you. Unless there's any other questions at the moment, I think I will hand over to James via Allison.
Allison, you've muted yourself.
Hi. Just before James starts his session, just by way of introduction, many of you will know James. James is, again, one of the family practitioners in Chambers who specialises in a variety of areas within the umbrella of family law, children's law, court of protection, international family law, financial remedies, and public access work. James has also, in the last few weeks, been doing a tremendous amount of work, both in Chambers, as part of the management committee, but also as part of his committee work with the FLBA around the challenges that we're facing because of the pandemic, for which we are extremely grateful to James. He's put a lot of hours into that, so thank you very much, James. And he will now, I'll hand over to him for his presentation. Thanks, James.
Thank you, Alison. And I think you should all be able to hear me. That, as you probably have all had as practitioners as well, there's been so much guidance from, I think, the President, McDonald, local guidance, and the like. What I'm going to talk about is just very briefly more McDonald guidance, give some references to some of the other more national, I'm in class as national guidance. And also what I think is very important for all of us at this stage that do the legal aid work is making sure we get remunerated properly and fairly for the work that we are now having to do. Because from my experience, that there was a concern, and rightly at the very beginning of when we were all told to work remotely, that we would all be putting in a great amount of work and being paid for an advocates meeting is one of the biggest concerns that we had. How would we be remunerated for the work that we actually do? But quickly looking at the guidance to start with, we all know what happened at the very beginning of the pandemic is when the President started saying that all hearings would have to be remote. And what by those means is we've all learned very quickly there are many ways to deal with it, and the court have had to get up to speed quite quickly with a vast amount of different sorts of technology and having a system that just doesn't work on their end either. But what I think we all need to remember And yet I have not heard of any cases when it is being classed as exceptional, that if hearings are so urgent, but it will be not right or fair, and Amanda's going to touch upon it later about the rights and making sure things are done fairly and correctly, even in these times, is that hearings can be and can still take place in live locations. My understanding, if, for example, those that practice in Hertfordshire, the nearest live court is Luton, and is no longer Watford or Hertford itself. But yeah, the description of sufficiently urgent, which can't be done remotely. And I think from reading what I've heard from responses from individuals speaking with practitioners, and I think it's very interesting. It's a very interesting article on the Transparency Project written by a former judge. An anonymous circuit judge has written an article saying how difficult they have felt on their side of making sure cases are done fairly and correctly. And I think that is for anyone should read that themselves. It's very eye-opening from an actual view from a judge. Which judge I don't know, but I think it's fair to say from what we've heard, it's a view shared by a lot of the judiciary going, what do we do? How do we make it fair? And actually it's a very artificial process. Like now I'm talking to, I think, over 61 of you, and I can't see any of you. That I will deal, I think I'll deal with that question, just come up in a moment. In a moment, I'll deal with at the end. Then you've got the president saying about blanket approval of e-bundles. I know most of us who do public law work, we're using e-bundles for over a number of years now, but I think it's now all proceedings can be done and undertaken via the electronic bundle system. Dealing with MacDonald J's guidance, I think in the space of 10 days, he's released his guidance 3 times. It is likely, probably in the next week or so, it gets updated again with more things that are being learned slowly by practitioners, issues that are being raised by people, and just practical experience of judges. I think the most difficult thing we all have, and I know there is loads of different local guidance of IT platforms, conferencing facilities, telephone hearings, should it be powwow now, should it be BT Meet, and so forth. What MacDonald J has said, and I think there's conflicting view then coming from different, I think the circuit judges' own organisation, own committee are questioning some of the things he said. But what he has said on behalf of the president is saying that in the interim, parties are able to choose from a suite, or as they say, smorgasbord of IT platforms. The reason for that, as he says in his guidance, and I think I'm not going to walk it through the whole guidance with you all because it's now numbering about 50 pages, is that because of the urgent situation that we are in and the exceptional situations we are currently in, he has said, and it's the new parties for references of paragraph 1.4 of his guidance is in red, says that even judges can use platforms that the court aren't able to provide technical support for. That is where he first makes his reference to saying there's a wide range of different people, and that the technology there, that we also have, as further on in his guidance, when he starts talking about the primary resource. I think most people are probably being told by the judges to use Skype for Business or telephone hearings. There's this query about Skype for Business, for practitioners, because actually Skype for Business is you can't purchase anymore. As far as I'm aware, when I've purchased it, it then turns me on to something called Microsoft Teams. And then that makes a great difficulty for us trying to go, because the court system is not being updated, they still use Skype for Business, which queries how we access it. But there's helpful guidance that is now in all these, in MacDonald J's guidance, him saying how you work your way around that is a problem. But if there are other issues, please don't hesitate to contact me, because there are other workarounds. But what he says is that he's copied and pasted the guidance the court has had from Her Majesty's, or the judges have had from the court service, recommending a number of what their platform is. But I think the key point is, whenever you have an argument, and if you have to have an argument with the judge, picking what platform is best for your clients. And I think this is where the argument is what is best for your case. A directions hearing for 10, 15 minutes by telephone might be, you feel, all appropriate in your circumstances. A contested hearing, why would it be right for a parent not to see who is making the decision about what is to happen, whether they are to be separated from their child, or decisions like that, is that the guidance is, and as quite clear in the guidance is, it should be, it's not a must. The guidance doesn't say they must use Skype for Business, or they must use, I think, BT Meet Me. It is they should. And I think this is where you will all get at the problem at the moment, is certain judges are very flexible, and I think that's being shown by the High Court, saying that, look, we'll use whatever's best for all the parties to make sure everyone has a fair right to the hearing. But then are more accommodating of it. And I think that's when the arguments come. But I also think the problem is judges are hesitant to use differing platforms because they don't know how to use it. And I think more the time progresses, judges seeing some of these, having had a show, or whether you put in a directions hearings, what I would say is ask for a hearing maybe a few days before for 10 minutes, advocate and judge, and you can go through the technical problems, show them how it works, so they aren't in a situation they're struggling when clients and professional witnesses are waiting to be giving evidence. The other issue that, and the guidance is very useful for, and this is why I think everyone needs to read it in detail, is it details how judges can work around problems they may have downloading apps, accessing accessing different things when trying to access it. One thing we will all encounter, and I know is an issue, but if you raise it with, I think, the appropriate people in the local authority, VIVE, necessarily the DFJs, is either the courts and the local authorities having access to the technology, because I have heard certain local authorities, IT departments have banned Zoom, for example, and other access things, bar Skype for Business. But if the courts order it, and this is why I think you would be arguing, if you've got a particular platform that works for everyone, is the court orders it, that then means the local authority have been, they've done their due diligence, I would say, and then can move on. CAFCAS, I've been told, is sorting out their problems, and there will be not issues. And as I think Rebekah's already shown, one of the technical guides the FLBA have done, they've got technical guides on most of the platforms now that can be requested and been circulated to show you how to do it. One thing for solicitors is that about how you issue applications and orders. One of the big issues, for example, in ancillary relief proceedings or private law proceedings and consent orders, is courts were going at the very beginning, and may still be, saying you haven't got what they class as an actual signature, or a wet signature on the document. You need to refer back to this guidance, which clearly says that is not a problem anymore and shouldn't be a problem at all. Moving on to the recording of the hearings, there's guidance now within it that says there's two ways to deal with it. The court can record it, but the issues the court are having is they've got no central database to put all these recordings in, and the judges' laptops just don't have the space to record. Or what they're now doing is putting the responsibility on the legal representatives, but having quite strict parameters, either in the order saying the local authority, generally who is generally the applicant, records it, you hold it as the lawyer for the local authority in a secure place, and in the future, when they've got the systems in place, you transfer the recording to the court, or, as I think Rebekah's already commented upon, you send it on the day, and then you agree that you've deleted it once you've confirmed the court have got it. Because the big issue is, I think, you send orders, and if you until you get the response, it's not sensible to delete it, because that's the only recording that you will actually have. Another issue which, and this is where I think Zoom is the right platform at the moment, is in respect to the question of interpreters. As we all know, trying to do anything with interpreters is difficult. The first thing I would say, though, is there is concern, and rightly, about how we will interpret these things properly, but we need to look at the basics again. And as the basics being that when we're in court, the interpreter is talking behind us. When we're asking clients questions in court, when they're giving evidence, there's the natural delayed interpretation. That can all still happen over platforms, electronic platforms, and Zoom has a special function set out in what they can do is that they can talk over in the hearing tape what to the client directly, because they have a direct link to your client, and that is how the interpreters work there. And in the guidance, it's at paragraph 5.13 through to 5.14, setting out a platform. And at the moment, the court's own platform does not work for interpreters. There's no way to do it. The only one that does is the interpretation through this platform. And if you read the instructions in MacDonald J's Guidance, but more importantly down Howe's document, it will set out how it can and be done. Intermediaries are more of a difficulty. That is more difficult, firstly because Community Court have postponed all assessments from the 30th of March. Because what is one of the difficulties they're having is Community Court, the intermediaries aren't key workers. For a start, they don't have the same support as we do as lawyers or social workers. They aren't classed as key workers, and they're very difficult still to actually, how are you supposed to be making sure the client is understanding and everything else like that. And I think that is one of the limitations of these virtual hearings, and it's very difficult to do. Rebekah has touched upon the question of security and GDPR. And I've heard certain senior judges have said, if you ask a client, is there anyone else in the room? And they go, no. And there is, in fact, someone recording it. That's the first lie of many they will probably tell. And the judges are going, there's not much else they can do. They just have to accept the difficulty of the situation we are all in. The other guidance, and I won't touch on a lot of it, is I know there's a lot of, and there's something in the Guardian today about all the issues that are now coming up in respect about child arrangement orders. That is something the courts are having to look at and deal with. But I think the first starting point is I would send to all clients who are having difficulties what the president has said about parents should look at parenting as parents. I accept that's difficult and stepping back and working what's going on, but there is nothing stopping contact. This pandemic doesn't stop the contact, but it has to be done safely and just thought about carefully. And that there's now guidance on how appeals are being submitted to the court office, especially the High Court. If there's urgent hearings, it needs to be labelled correctly and it won't be missed then. Just one issue that Rebekah touched upon briefly was litigants and persons and lay parties going to access and participate in remote hearings. That is a difficulty that no one has an answer to at this moment. There are certain local authorities purchasing laptops, iPhones, smartphones for vulnerable children and parents that local authorities are looking into, I understand from discussions I've had, in making them available in certain circumstances. But one of the difficulties is, and I think it's fair on the Transparency Project as it touched upon, this feels very artificial, even for us as lawyers. How much, what do you think it feels like to parents who are in the vulnerable categories, who don't know, don't have access, don't really know how to deal with this? Them participating is very, very difficult. And I think what we need to be careful about as lawyers is speaking with our clients and making sure they actually rightly feel and not being scared to ask that. But I don't want to tread on this too much because Amanda will touch upon it later on. The other issue is, as I've touched already, there's local guidance which is kind of overruling some of this stuff, or judges taking differing views on how to deal with things. Hopefully that will be addressed, because that is being fed back to the president saying we are having difficulties practicing different areas having different rules, which makes our lives a lot more complicated and difficult. What do we do? And the question that as I've said, is what's going to happen with all the cases we get adjourned, that we are adjourning for the client's interest. And the difficulty is we're adjourning cases saying the clients can't participate properly, but we know the system at the moment was full, was creaking. We're now adjourning cases, and I think fortunately they've already spotted that as a problem, and Lord Justice Baker and Mrs. Justice Judd is looking into redeploying resources when it all passes over. Now, what I think is possibly some people might say is the most important part of this presentation is the guidance from the Legal Aid Agency. I'm aware more guidance is going to come out shortly, and I would advise everyone to keep checking the Twitter feed on the FLBA over the next few days, or at least next week, because more guidance is going to be produced. But what needs to be quite clear, advocate meetings does not limit in public law proceedings, but the issue is in respect to private law proceedings and domestic abuse proceedings, for example, non-moles, etc. There's no provision for advocate meetings currently. That is being looked into. Then looking at what evidence is required in respect by the LAA for advocates meetings, claiming them, is, as we all know, needs to be recorded in the orders. Even retrospectively, the LAA have indicated that if you've had to, especially trying to deal with cases now at the beginning of when you've got hearings listed in a week, 2 weeks time, there's no advocates meeting because it wasn't thought about previously. Get it put on retrospectively on an order, but also they are now accepting, if an email to a judge is asking for confirmation, I want an advocates meeting, etc., they are accepting the emails from judges confirming it through that without having to have a necessary formal order. That in respect of FAS forms, there's no longer a requirement at this stage for them to be signed. I know at the very, very beginning, lawyers were scanning FAS forms to judges printing them off in the court office, scanning them back with signatures and so forth. But what has been indicated in respect of that is no longer necessary. What needs to be done on any order, private law, ancillary relief, or private law children, is make sure all the advocates' names are properly set out on the face of the order, that you are identifying the times that you were attending, times for pre-hearing discussions, post-hearing discussions, when the hearing was actually listed. I've got wording at the end of these slides of what I would suggest to put into it. And then that should be sufficient for the Legal Aid Agency. And what can be claimed are all the bolt-ons that are on the FAS forms. You just need to list those on the orders. And also in respect of page counts, etc., all they will require, and they may require more than the order on occasions, is you printing off and attaching the index for the trial bundle to show that your bundle has gone over 350 pages. Or you've got, maybe have to refer them to where, if your client has difficulties giving instructions, maybe the report. But I think some of those things having to be done already and have been done previously, but it's just confirmed that is not an issue at this stage. In respect of hearing times, what can be done in respect of that, it does say within the guidance you can do a hearing with a judge by email. That doesn't actually have to be done by phone, by remote platform. They will bill and will allow you to claim for email hearings. What the guidance quite says, don't take advantage of that and saying, oh, we've been emailing for the whole day, that's 9 hours. Can I have payment for those 9 hours? Because that will cause the difficulty when the pushback will come back from the Legal Aid Agency. But they've said quite openly to us that if you've got a hearing at 9 o'clock and it starts, and do you do it all by email and finishes at 11 o'clock or 11:30, 11:45, they will pay the necessary units when that hearing has taken place, with the evidence of those orders and the email saying it was done by email. The other thing that can also be done is those clients, when you speak with your clients prior to the hearing, that you can claim an advocates meeting at, say, 8:30 to 9 o'clock, then add on to that, then the hearing time from 9 onwards. But the caution just needs to be had in respect of that slightly. But all of this is commented upon. There's a link at the end of these slides to the article or document on our Chamber's website. And also there is reference in McDonald's guidance in respect of what the LAA have said to him as well. That The other key thing, and when I use the word cancelled hearings here, is we all know when we've gone to court, we deal with a hearing and we can get consent order and it's sent into the judge. What that can be claimed, and also what also can be now claimed, is if you get a hearing and the judge cancels it the following day, that if you, and these are the self-employed advocates, so I think it's more difficult for the solicitors to do it at this stage if you aren't an advocate for the firm, is that they will allow you to claim 1 hour's unit for the work that you've done, even if you've done over half an hour's worth of work. I think, again, as with the email hearings, I think we need to be careful not claiming and taking advantage of the system, but that's useful, especially when courts, you are now having courts cancelling hearings at the last minute, and we just don't have the technology, we don't have the judges, etc. You can still be recompensed for that. That just now, I'm not going to read them because you will get all of these slides sent to you. There's wording what I put on top of all my orders, and I understand is acceptable and approved, is you listing when you've all turned up, all the little minutes, etc. on that, and it's referring the LAA agency to the necessary information. And then finally, I know when I spoke originally about this, people were going, I'm a bit concerned if I'm putting on an order, my client is lacking the ability to give me instructions, or was difficult giving me instructions. I advise to put all that sort of information in a schedule at the end. That there's the links to the guidance and also the links to the necessary websites. And I think then that is everything I have to say, and I will answer any questions that have been asked at the end. So back over to Alison.
Thank you very much, James, for a really informative and extremely helpful presentation there. And as James has mentioned, I can see there are a number of questions arising from James's session, and we will come back to those questions, don't worry, to deal with them at the end. So now on to our third speaker. I'm very, very pleased to welcome one of our wonderful public law silks in chambers, Amanda Weston QC. Amanda practices in public law, human rights, civil liberties and equality law, and she specialises in representing vulnerable clients in a range of jurisdictions. Just a couple of important cases that Amanda currently has. She is acting in a case called T. This is a case pending in the Supreme Court concerning secure welfare accommodation under the inherent jurisdiction for a transgender teen, and also in a case VC, which there's another case pending in the Supreme Court concerning access to justice for a detainee with impaired capacity. Amanda is on the A panel of counsel representing the Equality and Human Rights Commission. And along with James, Amanda recently conducted a Court of Appeal case on injunctive powers of the court in FGMPO applications. So over to Amanda Weston.
Thank you very much, Alison. So I'm going to be encouraging people to think a bit outside the box when looking at solutions for access to a court. In a time of crisis, when well-established procedures are of necessity being abandoned and replaced, we can sometimes forget why the procedures are as they are and what the key features of a fair procedure are. And so I'm going to speak a little bit about the underpinning principles, particularly for those who might struggle to access court procedures on an equal basis in any event. It's not a counsel of perfection. Children's welfare obviously demands that cases proceed, but more a toolbox to help you ensure that in departing from established procedures, alternative ways are found to protect clients' access. And we also have to be aware in times of cost cutting that a lesser measure of fairness does not become the new normal, and be careful to record and ensure that courts record when an alternative process becomes unsatisfactory. So I've listed there, I'm not going to go into them, the sorts of vulnerable client groups and the issues might arise for clients accessing fairness in remote hearings. Rebekah's already described her experience, and James has given some examples of differentiated procedure which is required when dealing with people who need support to access the process. It's encouraging to see that in the third version of Mr. Justice McDonald's guidance that both Rebekah and James have referred to, that the President of the Family Division is quoted there. That really is the essential thing to bear in mind when looking at operating the remote hearing processes in practice. The question is, how do you achieve it? Because of course it's not just the practical communication which you get during the court hearing, but also the process of bringing people together, the personal contact, being able to support with your presence and with your confidence as an advocate, somebody who needs empathy and reassurance, the support they need in time and place, and the gravity and the seriousness of the environment, making sure that people are protected who find the process of a court hearing a foreign and an alien environment in which they are nervous to assert themselves and assert the difficulties that they might be having. So I've just picked out some aspects of the version 3 of the Judicial Guidance which seem to me to be drawing everyone's attention to those difficulties. And in particular at paragraph 515, Mr. Justice McDonald has there stated that there will be a particular need for the judge to set out from the outset the clear ground rules. And I think that what that is referring to is that the same might not be appropriate in all cases, that this, because we're all feeling our way and trying to work out how to access justice for people who would struggle in an oral hearing, struggle with the presence of their advocate, how they're going to manage without that presence and without possibly the facility, the technical ability to participate to a full extent. So where do we find those underlying principles? So the reason I thought it might be helpful to go into the fundamental principles underlying a fair hearing is because one of the things that happens when we are when we get used to a process and when we're very, very familiar with procedures is that they sort of harden into having a life of their own, and we forget how they were developed and why they were developed. And it's getting back to that how and why which is important to underpin any departure that we make from those procedures. So there I've set out the basic sources of law that I'm going to be referring to. You've got common law principles of access to justice, and the domestic courts are clear that both the common law and human rights principles regarding procedural fairness march hand in hand. Then you've got Article 6, the right to a fair hearing of your civil rights and obligations. You've got Article 8, procedural safeguards. So that's the importance of Article 8 in generating a right not only to have your right to private and family life respected, but also the means by which you seek to vindicate those rights is also protected. That's to say, your access to a court, your access to a fair process. Then you have Article 14, the right to equal treatment in the protection and vindication of fundamental rights. That's the prohibition on discrimination in the Convention. Also the Equality Act 2010, which makes provision for the prohibition of discrimination against those with a protected characteristic. And then there's some international instruments which are, although they might not be of direct application in the domestic courts, nevertheless the courts will refer to them when they're looking at the detail of a more general human right. So what are the principles governing fair proceedings? Firstly, the principle of open justice. Plainly, that process, that principle is going to be very difficult to maintain in the context of remote hearings. And indeed, in the last week or so, journalists have been explaining how their experience of trying to access proceedings, although they've given permission to access proceedings, nevertheless, that's been difficult. And the reason why we have a principle of open justice, and the reason why, even though family proceedings are maybe in private, nevertheless the judgment will normally be in public, albeit anonymised, is to give the sunlight of external scrutiny to what might develop. I've heard it described as unhealthily as an upturned petri dish without the sunlight of public scrutiny. Then there's the principle of the equality of arms, the right to have an even playing field with your opponent or opponents, the right to be heard, the right to know the case against you, that's so that you can make meaningful representations, and unimpeded access to a court as a common law imperative. And that right as a fundamental common law right, independently of the Human Rights Act, was recently underlined by the Supreme Court in the Unison case, which was about the cost of access to employment tribunals being raised so high that individuals were impeded from bringing their claims. So the first thing to remember about common law procedural fairness is that it's a flexible concept. I've put the 6 principles of the Doody case down and on the screen. Although
incredible. I mean, you just wanted an Oscar. No. I think you did.
Is it possible for somebody to mute there? That seems to have been done. I'm grateful. So the standards of fairness are not immutable. They may change with the passage of time, both in the general and in their application to decisions of a particular type. Obviously, proceedings concerning the future of a child, the welfare of a child, the relationship, family relationships are of a fundamental character which attract the highest standards of fairness. For a reason I don't know, here we go. There seems to be a delay in moving screens. Yes, so the principles of fairness are not to be applied by rote identically in every situation. What fairness demands is dependent on the context of the decision, and this is to be taken into account in all its aspects. So that means that where your client's underlying specific issue is of such gravity, you are entitled to insist on the highest standards of fairness. That's something that you should always pray in aid when looking, for instance, for a change to a procedure or for a specific allowance to be made in order to access the highest standards of procedural fairness in a particular case. Then the essential feature of the context is the statute which creates a discretion. So for instance, in situations where a local authority or another public authority is making a decision in regards to a child or which engages family court jurisdiction, then plainly the type of statute which is under consideration and the particular power, such as, for instance, the power to remove a child, is of fundamental importance when gauging the degree to which allowances must be made to achieve a procedural fairness. Fairness will very often require that a person who may be adversely affected by the decision will have an opportunity to make representations on his own behalf, either before the decision is taken with a view to producing a favourable result or after it's taken with a view to procuring its modification. And that plainly is a principle which local authorities will have to bear in mind when working out what their procedures are going to be for families who are engaged in measures pre-decisions to take court action or to bring proceedings in respect of a child. And then the last principle is that since the person affected usually cannot make worthwhile representations without knowing what factors may weigh against his interests, fairness will very often require that he's informed of the gist of the case which he has to answer. Now that's a very loose description in the context of the facts of that case, which was, it was a prison categorisation decision. But when we're concerned with the interests of a child and family relationships, we are obviously going to be talking about full disclosure of all reports and relevant material, which has founded decisions being made. So then Article 6, which is incorporated under Schedule 1 of the Human Rights Act 1998, provides that in the determination of civil rights and obligations, everyone is entitled to a fair and public hearing within a reasonable time by an independent, impartial tribunal established by law. So it's important that the rigour around ensuring that access to the court is equal and that the court is acting on an equal basis and treating everybody equally is going to be of particular significance in the context of remote hearings, where some paths and routes of access to the court and the technology that's used are going to be very available to some parties and not so available to others. It's going to be important to ensure that parties, and particularly litigants in person, have that same access to the court that the profession has. How that's to be achieved remotely, obviously, is a serious issue, and it may in fact reiterate the need for the government to re-examine the provision of legal aid in family cases which are currently out of scope. It's quite nice to look at the case of McMichael, which was a Scottish case about lack of access to reports. They were provided to the parents in respect to the adoption case, but only at the hearing. And there was a complaint here not only about Article 6, but also about a breach of Article 8. And the court found, in fact, that both articles have been breached because the practice of failing to disclose in advance reports revealed a basic inequality and placed the parent at a substantial disadvantage, both in respect of bringing an appeal and in the subsequent presentation of any appeal. So any procedure which is adopted, which places parents or family members or any party on a differentiated footing from another party, is sufficient to invoke Article 6 and for representatives to seek adjustments made to the process to ensure equality of access, whether it's to disclosure or any other aspect of the hearing. Then we can see in the domestic context the reference to Article 8 procedural safeguards. In the Riel case, Mumby J made it absolutely crystal clear that Article 8 guarantee of procedural safeguards, of procedural fairness, doesn't just apply to the proceedings itself, but also in the decision-making process at all stages of child protection. Then just looking at the Equal Access to Justice toolbox, the anti-discrimination provisions of the Equality Act. There you can see Section 4, the protected characteristics set out. And then I've made particular reference to the definition of disability there in Section 6, because it will frequently be an issue of disability which is preventing access to proceedings, or failing to ensure equality of access to proceedings if allowances need to be made. Of course, remembering that vulnerable adults may not come within the definition of a disability, but nevertheless need support, because their decision-making ability might be impaired in some way. That could also be through a question of undue influence, but again, the principle is that support for equality of access. So then, in addition to those categories I've just taken you to, we can see here summarised the parts of the Equality Act which are most likely to be usefully prayed in aid when seeking changes and adjustments to the process of remote hearings. Sections 20, 21 and 29(7) of the Equality Act set out the duty on public authorities to make reasonable adjustments when asked to where an individual who has a disability suffering from a substantial disadvantage. That's an anticipatory duty. So it would perfectly approach, you don't have to wait until your client's facing a difficulty. The thing is to flag up that the client has a difficulty, is at a substantial disadvantage by way of disability, and ought to have a particular process. And as long as it's reasonable, it shouldn't be refused. In fact, where a public authority is asked to make a reasonable adjustment, if they refuse to do so, the burden shifts to them to show why it shouldn't be done under Section 136, or why it's not reasonable. Then you've got the general public sector equality duty. I actually haven't seen very much mention of the public sector equality duty in the rafts and rafts of guidance that we've been receiving over the last couple of weeks. But I do note that the Home Affairs Committee has been asking for evidence about the way that vulnerable groups and groups with protected characteristics are experiencing the changes to all processes, in particular accessing courts and accessing services. There I've mentioned the United Nations Convention on the Rights of Persons with Disabilities. It may seem like overkill when there's already so much domestic legislation, but it's important to remember that Article 12 of the UN Convention on the Rights of Persons with Disabilities particularly safeguards the right to legal autonomy, to equal recognition before the law. And what that does is places a burden on states parties to ensure that they have processes for supporting people to make their own decisions and access and engage in legal processes for themselves, rather than having decisions made on their behalf, whether they, even where they lack capacity. That is a process which is safeguarded under the Mental Capacity Act. But nevertheless, if you might have a client who has a disability but does not lack capacity, but for whatever reason, they are not being adequately supported to access the process and participate on an equal basis as another party to the process. And in those circumstances, it's perfectly appropriate to cite reliance on the UN CRPD Articles 12 to 13. 14's dealing with liberty and security, which may arise but is less likely to. And that's my presentation. I hope that's helpful.
Thank you very much, Amanda. That's been extremely helpful indeed. We have a few questions that people have been writing in during the course of the presentations. We've got about 15 minutes left now. There are four questions. Perhaps if I could just give these to James, Rebekah and Amanda in that order. The first one here comes from Barbara. It came during James's presentation. Barbara says, if guardians aren't allowed to attend court in person, is it fair to expect lawyers or lay parties to attend? James?
I think that's the difficulty, really, and I think that this is the discussions I've had. The guidance is quite clear. Public Health England is saying that we shouldn't be attending. I know the position of the FLBA is that lawyers shouldn't be attending either, whilst the guidance is that we should be working from home, socially distancing. And I think McDonald J accepts that. But I think what he's done is put an exception in it to enable it if everyone felt like that was what's to be done, because within MacDonald J's guidance under Appendix 2, there is guidance on how to make a live hearing safe as best as possible. It's going to be one of the arguments that's going to be raised. If social workers don't have to attend because they're vulnerable, or guardians aren't supposed to attend because of the risks to them as a whole, then you're saying, why should lawyers and parents having to attend? I agree. Why should we be needing to attend? I think the difficulty is if the court is, it's the balance between the urgency behind something and making sure if it's an urgent hearing and your client is going to struggle to participate in the hearing for whatever reason, it's the balance the court and everyone will have to have, and it's going to leave open appeals. I think I agree. Why should we have to attend if a guardian doesn't? So, and I agree with that comment.
Thank you, James. Rebekah, there's a question here from Maria. This is Maria's question. I act for a 17-year-old mother. She is subject to a care order. LA are seeking to separate her from the baby. She was in a foster placement with her child. The foster carer has given notice to change the care plan, returning to court in order to change the care plan. Mother is vulnerable and has an intermediary. How can the removal hearing be done fairly as the intermediary is in isolation?
Well, I'm not sure that it can. I don't know if she can move to another foster care placement, because obviously you can't make the foster carer carry on. She can just give notice. But that's really difficult, isn't it? It'll be very difficult for the court to fairly sanction separation when it's down to things beyond the mother's control and don't seem to be anything to do with her care. I don't know if that helps you, Maria. You can message me directly as well.
Alison, I was just going to add to what Rebekah was saying. I think the difficulty is that the local authority are going to have to justify why a mother and baby foster placement is no longer necessary, because it's just no different to a normal situation that a foster carer gives notice. They've decided the mother and baby was working, and that then the carer is giving notice. If she's just given notice saying, I don't want to do this anymore, they've got to justify the complete change in proceedings. And there's no guidance to make sure that hearing can be fair at all, really. But I think that's going to be the court having to balance the urgency and the need to having the removal or the separation in the circumstances.
Thank you, James. Amanda, perhaps you could deal with this one. It comes from our very own Maggie Jones. Maggie says, I have a case in which the judge has now accepted that she has to hear from the parents in person because credibility is crucial. So the suggestion is that each parent attends a court in person in front of the judge with their advocate when they give evidence. Without this provision, we would say that the hearing could not go ahead. I don't know what you think of the dilemma that Maggie's highlighting there, of where you've got the whole issue about effective participation. You've got parents where credibility is crucial, and the judge saying, well, you've got to come in person and be before me.
The courts are quite used to taking oral evidence over Skype and other systems. And I'm quite surprised that the judge feels that the video systems that are available aren't suitable to determine credibility. I'm wondering what it is about those parties which might make it more difficult. You know, are there other issues apart from the fact that oral evidence is required? Because courts frequently make decisions on credibility over video links.
Can you hear me?
Yes, Maggie, I was just looking for you in the list to ask you to jump in.
Yeah, I'm going to jump in here. It's a very complex case where the parents have relinquished the child for adoption back in 2018, and here we are in 2020, and and there's proceedings, and the parents have turned their life round and want the child back. We have a psychologist who we're hearing evidence from, who makes all her decisions on psychometric testing. And actually, you know, given what the psychologist says, and given the circumstances of this, and, you know, it's an adoption at the end of the day. And for parents, with parents who've turned their lives round, they need, and the judge has accepted, that actually it's not just about how you respond to questions, it's about your whole, you know, your body language, how you deal with things in front of the judge. And the judge actually has accepted that is right. We've been batting back and forwards as to whether we can go on or whether we actually should adjourn this final hearing. We are part heard already, I have to say. But I think that it's really important that the judge in those circumstances and in lots of other circumstances can see in person the parent when they're giving evidence. I don't think that can be done remotely. I think lots of other things can, but I think there are limits to it.
It might be, if you were in the position of seeking to persuade the court that this was one of the of MacDonald J's necessary oral hearings, then obviously you'd pray and aid all those factors. I'm just aware that courts generally don't shy away from making credibility assessments.
Well,
I'm wondering whether when looking at changes to procedure, whether bearing in mind what you said about the psychometric testing, whether it's not one of those cases where the court might not be assisted by a more in-depth assessment of the parents.
Amanda, I cannot tell you how much the court would be assisted by that, but, you know, we've had argument after argument from that.
It just seemed to me that that's the kind of, if it's a straight decision, bearing in mind that as Rebekah was saying, there's always going to come a point where the children's interests demand that there's a ruling on the issue, then it's going to be a question of, can we find an alternative means of making sure the judge has the best evidence in the circumstances, and if we can't, can we persuade the court that it's an appropriate case in which it's necessary to hold an oral hearing?
Well, actually, the judge actually has, leaving aside the issue of the psychologist in this case, which is a completely different issue, but the judge actually has accepted that she needs to hear and see the parents in person when they give their evidence. But, you know, what she wants to do is to set up a situation where each of the parents can be in court giving their evidence with their advocate there, nobody else there, everybody else is there remotely.
Will the child's welfare permit of it being adjourned off?
Well, yes, actually, entirely, because this is about, it's an adoption case and it's a complex adoption case, and this is about, you know, the rest of the child's life.
Well,
yes.
Seems to me then that's your option, isn't it?
Yeah, well, I know, but you know, it's taken a fight to get there, and we're not entirely there yet. But I just say, because we had a fight to you know, persuade this judge that actually she really has to hear in person from these parents who actually assess them in the context of the whole case. And I think that people need to think about that very seriously, because I think especially when the issue is adoption, at the end of the day, if there are really complex issues, the judge needs to hear from the parents in person.
Thanks, Maggie. I entirely agree with you on this. It's a complex and it's a really important matter that we shouldn't lose sight of.
Yeah, and this has taken a long fight to get as far as we are at the moment. So, you know, I don't know what other cases there might be around, but, you know, and I know some courts are adjourning cases where other courts are saying, get on with it. So, you know, it's partly a geographical issue, you know, in which court you're under.
Yeah, thanks. Thank you, Maggie. I think we've got one more question, but we may only have 3 more minutes of our allotted time. But I'll see if we can get a very quick answer on this one from anyone. This is a question from Catherine. The LAA can sometimes be difficult when instructing solicitor attends a hearing to sit behind counsel. If instructing solicitor sets up the Zoom call and therefore has to host, will this be easier to justify your attendance on LAA? Is this something that needs to be contained within the order? James, brief answer on that?
Brief answer is, I think it would be more easier to justify, but I think you'll have to justify why counsel can't do it, because, and I think there's justification behind that. But what I would say is, if Catherine emails Chambers, I'll see if I can get some more detailed information for her about that.
Could I just say, this is Maggie coming in. I've been in 2 cases recently where the court has said, I mean, this is before this, you know, anything like this has been happening, that actually the solicitors have needed to be there because of the vulnerability of the client, and has made that very clear in the order. Now, it seems to me that where we are now with remote hearings and whatever, that may be even more crucial when the solicitor knows the client very well and that they are very vulnerable.
Thank you, Maggie. Rebekah, I know you wanted to add something to your presentation before we close.
Just a few things for people to think about if they're still with us, all 55 of you. 4 things. First of all, remote hearings are really tiring, and don't underestimate how tiring they are if you're thinking about covering more than one. Second of all, it's a real lottery at the moment what judges are dealing with and who's adjourning things. Lots of things shouldn't be adjourned that are being adjourned, and I think we need to challenge some of these adjournments by way of appeal because of the complete geographical lottery that children face in whether they have a hearing or not. And just third of all, obviously child protection issues rocketed in both Italy and Denmark, along with domestic abuse. And so I just hope we can support each other through this really horrific time for lots of children that we deal with in our cases and families. And thank you.
Thank you, Rebekah. And can I give a big thanks to all our speakers, Rebekah, James and Amanda, who've provided some really thought-provoking, informative presentations. And I'd like to thank all the participants, those who, a few have had to leave now, I know, but there's still a lot of people online. I'd like to thank you all for attending, for your very helpful and useful questions. And just a few things to bear in mind from Garden Court going forward. It's all on our website, but just to highlight that we have the Domestic Abuse Initiative, where Chambers are offering support and advocacy. We have our ongoing support for organisations such as Southall Black Sisters, Rights of Women, where we're providing advice and pro bono work for key workers. Again, this is part of the initiative that's on the website for more details. And of course, you know, the thing is, the Lord Chancellor really should amend the provision so that everyone can get public funding, and we shouldn't have to be relying on pro bono initiatives, but there you are. Thank you. I should also thank Amy Hughes and the rest of the IT and marketing team at Garden Court for putting this together and helping those of us, myself included, who are not particularly technologically minded, to actually host this. And I hope that people have found it informative and instructive. The wonderful thing about family lawyers that I find, and I'm sure you do as well, is that when you go to court, we do actually support each other. And in this time of crisis, we're going to lose that human touch where you go to court, see somebody you know and say to them, oh God, I'm doing this particular case, or I'm in front of this particular judge. What do I do? Any help, any guidance, any assistance? Those kind of chats, we can't have them because we won't physically be in court. But please bear in mind that Garden Court family team are here to support you. You're here to support each other. We should phone each other, talk to each other, provide that mutual support. And as I say, the presentations have not only provided very practical help for those of us who have to do these remote hearings, but also reminded us, in particular, in Amanda and Maggie's discussion at the end there, of the fundamental principles that quite often would get lost in times of crises, and judges will simply say, well, we are in difficult circumstances, so therefore corners have to be cut, etc. We need to make sure that we hold the line on these things. Effective participation and the rights of our clients are fundamental. So thank you to everybody. Please take care and stay safe. And bye.